There's another sort of triumphant but also sad case today. A guy was convicted of murder 30 years ago, and he'd always protested his innocence, and he'd had, his appeals knocked back, and indeed the Criminal Cases Review Commission had knocked back his first application. However, upon a fresh referral to the CCRC, that went to the Court of Appeal, and yes, they have overturned the conviction. So how did this arise? Well, this guy was charged with murder of a shopkeeper, effectively as an accessory, being there with somebody else. And he did confess to the crime. However, he'd had a head injury as a child that had left him severely disabled. They reckon he had the sort of reasoning capacities of a 7-year-old. And also he was particularly subject to acquiescing. He had this thing where he would just always agree with people. And he was interviewed for about 14 hours, sometimes without a lawyer being present. And he just went along with what the police said. But at the trial, an expert said, no, he can understand all this. But it's the expert has come forward now and said, actually, now that science has moved on, my opinion has very, very much changed. And I would now be saying, no, this confession, this interview, it's not reliable. I mean, there was other evidence in the case to do with, clothing and things like that. Although the guy who'd been charged as the principal said, actually, it's not him. He wasn't with me. It was this other guy. The Crown actually asked the Court of Appeal to refer it back for a retrial. I mean, obviously he's served his sentence now, but they said, go back and, we should have another trial to see whether or not he really did it. But the Court of Appeal have said, well, no, because his mental condition is even worse now, and he can, he probably wouldn't even pass the test for sort of, can he have a fair trial? Can he understand what's going on? Can he instruct, lawyers properly? Can he defend himself properly? So now, as far as the law's concerned, he is an innocent man. But this gives me an opportunity to talk about something else, because somebody raised in the comments when I did about the confessions one previously with the Lucy Letby notes. Somebody said about what if people have sort of, under a disability. Well, that's Section 77 of the Police and Criminal Evidence Act covers that. First of all, the court has a general power under Section 76. If they're not happy with the interview, they can actually exclude it and say, no, we just don't think this is reliable. And like I said, the test is it must be excluded if it's unreliable, notwithstanding it may be true. But what if it goes in, but the court still has some concern, some unease about the defendant's mental capacity? Well, then Section 77 allows a judge to remind a jury, and indeed to warn a jury, about the danger of relying too heavily on admissions where somebody may be particularly vulnerable. So how do they do all this? What sort of tests? Well, just to sort of go for a little aside, I actually went to a really interesting seminar once where it was all about the psychological tests that they use in the justice system, in both, mainly in criminal, but also sometimes in civil for like capacity and things. Now, as part of that, we actually undertook the tests because they wanted to illustrate how the tests were done, but also how they test for people trying to fake the tests, because obviously it might be in your vested interest to sort of imply that you are not fit to stand trial, or that you were not of sound mind at the time you committed the offence. And there are some interesting techniques in how they actually can spot malingering and faking. But I sat the Ways 3 IQ test, properly administered. I scored 68. That's basically that's only sort of like 3 above actually being deemed to be able to actually sit through a trial, let alone conduct one. I mean, my argument is that these things just test how good you are at doing puzzle books. I mean, seriously, people have often said that, including Ising, who came up with IQ tests. They said the only thing IQ tests really test is how good you are at doing IQ tests. But they don't just look at, it's not like one of these online ones where, oh, congratulations, you're a genius, please sign up to Mensa and give us loads of money. There are different types of tests, and they're more concerned with things like suggestibility and acquiescence. Because, somebody might be, very, very intelligent in a book sense, absolutely, string of PhDs and all that sort of thing, but they might not be very good at sort of resisting questioning. It might be they just agree with what people say. So how do we deal with this when people are interviewed? Well, if the police think somebody's vulnerable, and children, minors are automatically deemed to be potentially vulnerable, then the police must allow an appropriate adult to sit in on any interviews, where they're interviewing the suspect. And who's an appropriate adult? Sometimes it's like the parent or guardian, if it's a child. If they think the parent or guardian isn't suitable, as to who, how much power the police have for saying, no, we're not going to let you in, that's all debatable. But if somebody comes along, say for instance the parent or guardian is a co-defendant or a suspect, or they think they may have coerced them, or they just think they're just not, up to snuff and they're not going to look after the child's interests, then the police can object to that. And usually then you'll get somebody from social services who will come. Now, the role of the appropriate adult is they don't take the place of the solicitor. You'll still have your solicitor there if you want one. You don't have to have one. But the appropriate adult is just there to sort of help assist the person being interviewed, calm them down. And also just to keep an eye and make sure it's not being too oppressive. This is why it's usually better if appropriate adults have some knowledge of the suspect, some personal knowledge as what conditions, because they might say something like, well, look, I know this person and they are very vulnerable, they are very suggestible, they don't like being cooped up in a room for long periods of time, they don't like overstimulation if you're raising your voices and things like that. That's the role of the appropriate adult. So what about, when this goes to court, how do you protect people? Well, now we do have specific training for, well, we used to call it vulnerable witnesses. And I suppose as suspects and defendants are witnesses, it's still appropriate. But originally this was all put in place specifically just for child witnesses, child complainants in cases. That's how it started out. And the idea was that you want to get the best evidence out of people. And when it comes to sort of children, then going in there and going, I put it to you that, you're lying and all that sort of thing, that's not necessarily, the best approach to get the best evidence. I mean, now we have these ABE, best evidence interviews. And I've actually arranged with a very nice police friend of mine has put me in touch with some officers who actually conduct these interviews. So I'm hoping at some stage to actually have somebody come on and explain how they do this. In a diversion from this channel, to actually have somebody on who actually knows what they're talking about, a bit of a novelty. But I have done the vulnerable witness training, so I can explain in broad strokes how it works. Now, the first thing to note is it's very much expanded now. Like I say, it originally started out aimed just at children, and just when they were sort of like giving evidence against people. But people say, well, hang on, what about vulnerable defendants? Because if your argument is this is the best way to get their evidence out, it should apply to everybody, because otherwise it's rather like saying only the complainants can have the hearing loop so they can hear what's going on, but the defendants can't. So if you're saying this is the best way of getting to the truth of the matter, then it should apply to everybody. So it extended to defendants, but then it also extended to just anybody under a vulnerability. Now, there have been some criticisms of this, including from me. For instance, it applies to people with autism, but my sort of criticism was it's a very much one-size-fits-all approach. And I know lots of people with autism, and they vary from, wow, you just wouldn't know, you might think they're a bit quirky, but they're geniuses, who could perfectly handle themselves in a trial. They wouldn't have any problem whatsoever, to people who genuinely might struggle a little bit. Now, there is some flexibility, but how do we do it? Well, when you have a vulnerable witness has been identified, you have what they call a grounds rule hearing. And that sets the ground rules for the parameters of your cross-examination and what you might do to make it easier. Whether do you pre-record examination in chief and cross-examination? Do you do cross-examination live but by video link so the vulnerable person is in a space that they feel comfortable? Do you have an intermediary that's somebody to stand with them or sit with them while they're giving evidence, who can just, provide moral and psychological support, but also perhaps interpret the answers. I mean, this was quite controversial because there was an argument as to whether whose evidence were you getting, the witnesses or the intermediaries. But these are the sorts of things you do, and you sort of establish, okay, this is how we're going to conduct the trial. But then also, the judge will set, the limits on how you question and what questions you ask. Now, speaking around with judges who make these decisions all the time, sometimes you will go in there and they will literally want a list of your questions word for word. It's like, here are the questions I wish to ask. A lot of judges, though, especially if they know you know what you're doing and you know where the limits are, they might just sort of say, okay, here's some broad bullet points as to areas you can cover and areas you can't cover, but we'll trust you to ask the questions. Because, of course, one of the arts of cross-examination is being able to respond to answers and adjust your next question accordingly. A very common bit of feedback I give on the advocacy training is, don't be a slave to your notes. Yes, you've worked very hard to sort of prepare all these brilliant questions, but sometimes a witness will give you an answer that you need to follow up on that might lead you down a particularly useful area. But there's also a policy, because with children you don't want to be accusing them of lying, you don't want to be distressing them. I mean, if what they are saying is true, then they've already been through enough trauma. You don't want to re-traumatise them through the trial. So one thing is, generally speaking, you do not put your case to child witnesses. You're not even allowed to. You don't challenge them. Because the usual rule in cross-examination is, if you wish to suggest somebody is not telling the truth, either deliberately or accidentally, then you must put that to them, what you say the truth is, and give them an opportunity to respond. I put it to you. Nobody ever says that in real life, by the way. But the way you handle it with children is, say they have accused a grown-up of doing something unsavoury, and the grown-up is denying it. You don't go in there and say, you're lying about Uncle Bill, aren't you? You say, well, Uncle Bill says this happened. Now, is Uncle Bill telling the truth, or is Uncle Bill not telling the truth? You do it like that. You never suggest they're not lying, but you give them the opportunity to say that the counter witnesses are. Now, interestingly, we talk about the different cultures in sort of jurisprudence. I do a lot of the international advocacy training, so I'm lucky I get to go abroad and, train with people in different jurisdictions. And I noticed this when I was over in Hong Kong. One of the issues with the students, I say students, they'd all been on feet for years. They were all like really, really good. Although the standards of advocacy over there, they are really, really strict. The first thing they said is, hey, we don't have any old touchy-feely safe space here. This is a pass or fail evolution. But one thing I noticed, and we did discuss this, was in Chinese culture, it's considered to be very, very rude to accuse somebody directly of lying or not telling the truth. So the way they would put the case, there was lots of, well, might it be that there's an alternative to what you're suggesting? They never actually said that you're not telling the truth there, are you? So that was very, very interesting, and that's something you had to take into account when assessing how they were doing the advocacy. And it's just I just find all this sort of fascinating. But it was interesting that sort of their approach generally is very much like the one we adopt for vulnerable witnesses. And yes, we do all the sort of like cuddly toy stuff and the anatomically correct dolls. I mean, somebody's actually pointed out that there was a problem with anatomically correct dolls because they just basically look like nice, interesting things, and yes, they've got furry bits and stuff like that, that kids just play with toys and, there's something there to dangle. So how much of that is them reliving an experience and how much is just saying this is an interesting toy? So a lot of the time, we'll use diagrams now, sort of anatomically correct diagrams, and say, could you point to? But also we do use just the cuddly animals, and if I can remember, I'll stick a picture of me at the vulnerable witness training with one that I really want. I've asked them if I can have it, and they've said no. It's we use this to train the witnesses, but I've said Mr. Fox wants to come to live with me. But yeah, this is why now though we have all this, because the idea is this will prevent miscarriages of justice like that happening, because now he would have the appropriate adult with him. to explain what happened. You would invite the judge to warn the jury about the dangers of overly relying on his testimony, and he might have even had assistance in court with how he gave his answers. So that's the general thing. But yeah, so there you go. As always, hope you found that vaguely useful, vaguely interesting, vaguely accurate, vaguely informative, etc., etc. Where am I today? I'm up on Pentire again on the headland, but I've hidden in a little. I've actually climbed down the cliff to get to this bit because it is so horrendously windy. But what I might do is I might just try and get you a bit of brief B-roll without actually stepping off the edge, just to show where I'm at. In fact, what I'll do is if I just spin the camera around now, just to save this, because I'm going to pack up very shortly because it's very, very scary here and stuff. But this is where I am, like on this cliff thing, which I managed to climb down to. But there's a lovely thing because there's like the big island round there. Actually, this is ridiculous because I'm now climbing, actually trying to carry a blooming tripod. But yeah, I hope you can see it, and I hope you appreciate that. Well, I know you all do. That you know, like I say, I always try and get these in interesting spots for you when I can. But like, yeah, I'm just so relieved that it's actually nice and sunny today. So I'll just do a little pan around. So there you go. I'm in my little hidey hole on the cliffs with that beautiful backdrop behind me, but I don't want to step too near the edge of the cliff. Just put this in follow mode because otherwise I will step over and fall down there, and I don't want to do that because I'm pretty certain that would spoil the channel.